Good morning. Welcome to the 2022 Team Policy Final Round. We are super excited about this morning's round. I'd like to introduce you to our affirmative team, the team of Trinity Kipp and Kaylee Whitaker. And our negative team this morning will be Mr. Ben Brown and Mr. David Hensey. Judges, we are thrilled to have you with us. Thank you for your service this morning. I'd love to introduce you to our debaters and to our audience this morning. Our first judge this morning is Dr. Craig Long. Dr. Long is a PhD in Theological and New Testament Historical Studies. He has a Master of Divinity with Biblical Languages from Southwestern Baptist Theological Seminary. He also has a Bachelor of Arts from Oklahoma Baptist University. Dr. Long was a pastor for 15 years before becoming an Associate Dean and Assistant Professor of Biblical Studies at the Waupun Correctional Extension Site. He and his wife, Angie, have been married for 27 years and have 3 sons. Thank you for joining our panel this morning, Dr. Long. Our next judge is Mr. Dylan McKinney. Mr. McKinley was homeschooled through high school. He's an entrepreneur at heart, and while he studied during homeschooling, he partnered with several organizations that allowed him to gain college credit in biblical theology and psychology. He now owns his own leadership development company as well as helps with his family business. Dylan plans to pursue the seminary in the future. Welcome to our panel this morning, Mr. Dylan McKinley. Next on our panel is Mr. Dan Rodriguez. Mr. Rodriguez has a bachelor's degree from Florida State University. He received his JD from the University of San Diego Law School. He is currently the Chief Deputy Prosecuting Attorney for Bonner County, Idaho. Prior to that, he was a defense attorney practicing both criminal and civil law for 8 years. He also served as the San Diego County District Attorney for 10 years. Dan and his family have been part of NCFCA for 3 years. Welcome to our panel this morning, Mr. Dan Rodriguez. Next, we have Ms. Elle Rogers. Ms. Rogers is a JD candidate at the University of Chicago Law School. She graduated summa cum laude at the King's College in New York City. She's a summer associate at the Washington, D.C. office of Gibson, Dunn, and Crutcher. And after law school, she already plans to clerk for the Honorable James C. Ho of the United States Court of Appeals for the Fifth Circuit. She competed in NCFCA for 5 years in team policy debate and multiple speech categories. Welcome to our panel this morning, Ms. Rogers. Next, we have Mrs. Lisa Schumacher. Mrs. Schumacher has an MBA from Cameron University and is currently the NCFCA Director of Affiliate Communications. She lives in California and spends most of her time, I would challenge that statement, in her garden. She is the mom of 3 NCFCA alumni that competed for 6 years in 3 different regions. Welcome to our panel this morning, Mrs. Schumacher. Next, we have Mrs. Christy Shipe. Mrs. Shipe has a BA in political science from Cedarville University. She's a former college debater in both policy and value debate. She's a debate teacher, coach, NCFCA debate curriculum author, piano teacher, and worship leader. In addition, she is obviously NCFCA's founder and a current member of our board of directors and the debate committee. Welcome to our panel this morning, Mrs. Shipe. And finally, our last judge this morning is Mrs. Andrea Shope. Mrs. Shope has used her bachelor's degree of education in curriculum coordination and in teaching. She's also been a varsity high school basketball coach and has been in the NCFCA since 2007 with her 4 children. They were in the league for 10 years, and now she has 4 alums. She's currently serving the NCFCA in a new role as the Christian School Liaison. Welcome to our panel this morning, Mrs. Andrea Shope. All right, just a few housekeeping notes. If you all would stay seated at the end of the round and allow our judges to be escorted out, that would be amazing. And if you would also only enter or exit the auditorium during downtime within the round. All right, you guys have a wonderful round, and we'll see you when you're done. Enjoy.
Good afternoon. As you know, my name is Kaylee Whitaker. I'll be the first affirmative speaker in today's debate round. Thank you all so much for taking the time to judge today. We really do appreciate it.
All right, my name is Trinity Kitt. I'm going to be the second affirmative speaker. Again, thank you all so much for taking the time to judge. We really do appreciate it.
Alrighty, my name is David Hinsey, and I'll be your first negative speaker. Thank you so much for taking the time to come out and judge us today.
And I'm Ben Brown. I'll be your second negative. Thank you for your time.
And if the negative can confirm 8 minutes? Awesome. All right, if everybody can hear me. All right, if my judge panel is ready, then I'll go ahead and begin. Quote, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury, end quote. The Sixth Amendment to the Constitution clearly outlines a right guaranteed to anyone accused of a crime, the right to a trial by their peers. When this right is systematically and intentionally abused, the very core of our individual rights is threatened. It is because my partner and I stand with the Constitution and the rights it enshrines to every American citizen that we stand resolved. The United States federal government should significantly reform its policies regarding convicted prisoners under federal jurisdiction. To begin with, we'll examine some context through background 1, acquitted conduct sentencing. Acquitted conduct sentencing. According to Michael Pepsin and Janos Martin, writing for Real Clear Policy, published September 27, 2021, quote, acquitted conduct sentencing allows judges to increase a defendant's sentence based on conduct of which the jury found the defendant not guilty, end quote. To give an example from the Cato Institute, quote, in Jones versus United States, the defendants were charged with both 1, distributing small amounts of crack cocaine, and 2, a conspiracy to distribute large amounts of crack cocaine. The jury convicted on the distribution charge, but acquitted on the conspiracy charge. But bizarrely, the judge in that case effectively disagreed with the jury's verdict, concluded that the defendants did engage in the charged conspiracy, and sentenced them far more harshly than would have otherwise been warranted. In essence, punishing them about 4 times more harshly solely because of alleged conduct for which they were acquitted, end quote. Now that we have a good understanding of what acquitted conduct sentencing is, let's move on to harm 1, undermines the role of the jury. Undermines the role of the jury. According to Jay Schweikert, research fellow at the Cato Institute and graduate from Yale and Harvard, published September 26, 2019, quote, under our Constitution, the jury trial is supposed to be the cornerstone of criminal adjudication. The independence of citizen jurors has always been understood to be an indispensable structural check on executive, legislative, and even judicial power. Yet prosecutors and judges routinely do end runs around the jury trial itself through the pernicious practice of acquitted conduct sentencing, end quote. Not only does acquitted conduct sentencing undermine the role of the jury, but it also undermines the Constitution, as seen in harm 2, jeopardizes constitutional protections. Jeopardizes constitutional protections. Also, according to Mr. Schweikert, quote, acquitted conduct sentencing is not only unjust, but flagrantly unconstitutional. Acquitted conduct sentencing is inherently at odds with the understanding of the jury trial in the Anglo-American legal tradition, and especially contrary to the special sanctity and unassailable finality of jury acquittals. Permitting sentencing based on acquitted conduct not only denies the criminal defendants their Sixth Amendment right to the jury trial, but also denies the community their proper role in overseeing the administration of criminal justice, end quote. Many current and past Supreme Court justices have also considered this practice to be unjust. Justice Scalia, Thomas, and Ginsburg wrote that such an increase of a defendant's sentence violates the Sixth Amendment, especially considering a jury's acquittal. Justice Kennedy raised concerns over acquitted conduct sentencing undercutting the verdict of acquittal, and Justice Kavanaugh defined this practice as, quote, a dubious infringement of the rights to due process and a jury trial, end quote. Indeed, over 80% of judges believe the practice is unjust. Numerous organizations, think tanks, and coalitions of judges and attorneys have also highlighted this blatant disregard of the United States Constitution and have voiced support for ending this unjust practice, including organizations such as the Cato Institute, the Due Process Institute, the National Association of Federal Defenders, the American Civil Liberties Union, and the American Bar Association. Therefore, to address these harms, my partner and I present the following plan. Mandate 1, Congress and the President will pass S-601, Prohibiting the Punishment of Acquitted Conduct Act of 2021. Mandate 2, an amendment shall be added to this bill ensuring that all other relevant federal laws abide by these new standards. Our agency and enforcement will be the legislative, executive, and judicial branches of the United States federal government and any other necessary bodies. Our plan will be implemented immediately upon an affirmative ballot, and no funding is necessary as this plan is purely legislative. Robert J. Anello and Richard F. Albert, writing for the New York Law Journal, published April 7, 2021, provide the following summary of this bill, stating, quote, the Prohibiting Punishment of Acquitted Conduct Act of 2021 would help restore the jury's primacy. The bill does so primarily through a narrowly tailored amendment to Code 3661, the statute that codifies the general rule that the judges may consider all relevant facts at sentencing by adding that a court shall not consider acquitted conduct except for the purposes of mitigating a sentence, end quote. Now that we understand the plan, let's move on to Advantage 1, preserves the Constitution. Preserves the Constitution. According to Jay Schweiker, research fellow at the Cato Institute and graduate from Yale and Harvard, published September 26, 2019, quote, whether through judicial or legislative action or both, the unconstitutional scourge of acquitted conduct sentencing must be abolished, end quote. Not only does our plan end a practice that flagrantly disregards the Constitution, but it also preserves the jury's role, as seen in Advantage 2, ensures the jury's sacred role, ensures the jury's sacred role. According to Robert J. Anello and Richard F. Albert, writing for the New York Law Journal on April 7th of 2021, quote, the new law would bring an end to a practice that has long troubled practitioners and scholars and would be a welcome step towards preserving the jury's sacred role in our criminal justice system, end quote. Finally, the third advantage to ending acquitted conduct sentencing is Advantage 3, unjust standards abolished. Unjust standards abolished. Under the status quo, the use of acquitted conduct at sentencing allows for judges to rule on the defendant's guilt at standards substantially below the traditional determinations of the U.S. justice system. According to Professor Yang L. Ngov, published in 2009, quote, having had a test run of the case at trial, the prosecution can perfect its case at sentencing with the added benefits of 1, proving the case at the lowest standard of proof, and 2, having a new trier of fact. Additionally, the prosecution can introduce evidence that ordinarily would be inadmissible at trial because the rules of evidence don't apply at sentencing. Moreover, at sentencing, the defendant loses the right to confront witnesses, a right afforded at trial, end quote. It is because acquitted conduct sentencing undermines the role of the jury, undermines constitutional protections, and is clearly unjust that my partner and I ask you to cast an affirmative ballot and pass the Prohibiting Punishment of Acquitted Conduct Act of 2021. Thank you, and I now stand ready for any questions the negative may have.
All right, are my judges ready? And y'all can hear me okay as well? Awesome, let's start. That was a great speech, Kaylee, and of course, congratulations on making finals.
You as well.
Just a few questions for you. Can I first see a copy of your 1AC as well as the bill you're enacting?
Yes, both are in this folder.
Okay. Okay, next, can we agree that the Supreme Court is the authority on what is and is not constitutional?
Yes, the Supreme Court is the authority, and the Supreme Court has ruled on acquitted conduct sentencing, but only regarding the Fifth Amendment and not the Sixth Amendment.
So it ruled it to be unconstitutional, is that what I'm hearing?
It ruled it to be constitutional by the Fifth Amendment, but no Sixth Amendment issue has been presented to the Supreme Court with regards to acquitted
So
conduct
to
sentencing.
clarify, the Supreme Court has never ruled acquitted conduct sentencing unconstitutional in relation to the Sixth Amendment, is that correct?
Correct, exactly. If the Supreme Court had, this wouldn't be a problem within the status quo. That is the problem the affirmative has presented.
Okay. Next, can we agree the role of the prosecutor in a trial is to convict the defendant?
Correct.
Excellent. So next, in criminal trials, the standard for prosecution is to prove the defendant guilty of a crime beyond reasonable doubt, correct?
Correct.
And the standard with acquitted conduct sentencing is if the evidence shows it beyond preponderance thereof, correct?
Correct. So acquitted conduct sentencing happens at sentencing
Right.
and not during the trial, so
Sure.
it is a different standard.
Right, but the standard is preponderance of evidence, correct?
Correct.
So 99% versus 51%, is that a fair summary?
Sure.
Okay, so what if, for example, the evidence indicates that it's 95% likely a defendant committed a crime? Should we consider that?
If we're looking specifically, if a jury is not able to convict somebody beyond a reasonable doubt, that's the standard within our criminal justice system. An individual should not be punished for a crime that they were not convicted of.
So if it's 95% likely an individual committed a crime, should courts consider that?
Unless the jury can convict an individual of a specific crime, they should not be punished for that crime. That's the standard and foundation of our criminal justice
So your answer
system.
to my question is no, is that correct?
I would have to see evidence specifically on the 95% number, but again, when we're looking at a jury trial, unless the jury convicts an individual of committing a crime, they should not be punished for that crime.
So the defendant's circumstances, except whether they committed the crime itself, ought not be considered. Is that what I'm hearing?
No, the defendant's circumstances are able to be considered, just
Sure.
not conduct for which a jury ruled them to be not guilty.
All right, interesting. Next, are judges forced to use acquitted conduct sentencing?
Yes, so we have evidence that judges are forced to consider acquitted conduct sentencing, and if they do not, they risk remand.
Could you present that evidence in the 2AC?
Yes.
Okay. Next, we can read that there are both congressional and judicial guidelines on prescribed sentence lengths, correct?
Correct, and acquitted conduct sentencing is used to increase that guideline.
Okay, right. But we can read that acquitted conduct sentencing can never pass the statutory maximum for the crime of which the defendant was convicted.
No, but that statutory maximum is incredibly high, so when we look at the range that they can sentence in, it might be somewhere from like 5 years to life in prison. So the guidelines are a more specified range. Acquitted conduct sentencing is used to increase that guideline range.
All right, no further questions. Thanks for your answers.
The negative team will be starting some prep time, starting in 5 minutes. Alrighty, I'm gonna set my timer for 8 minutes. I've got 8 minutes on the clock, and if all of my judges are ready. Alrighty, then we'll go ahead and begin. The affirmative team's plan sounds really good, right? We don't want to convict people who obviously haven't committed crimes. It sounds like, well, yes, of course, we wouldn't want to sentence somebody who hasn't committed a crime. We wouldn't want to simply tack on simply because the judge wishes to add more time. However, this is actually based off of a few misunderstandings, which I will be clarifying throughout my speech. First of all, I'd like to go ahead and simplify the affirmative team's position to a few main issues. First of all, they wish to claim that acquitted conduct sentencing is not held to a constitutional standard of evidence, therefore we must abolish it. Their second tenet is that of how the jury's roles are currently being negated. Now, I've got some responses to this, or rather some clarifications, which I hope will shed some light and cause this debate to be a little bit more clear. You can take my first point in response to those two main arguments of the affirmative team. You can, as the roles of judge and jury. The roles of judge and jury. Judge Deborah L. Cook in 2008, in the case of U.S. versus White on the 24th of December 2008, ruled, quote, when a layperson expresses frustration that the court system does not seem to respect the juror's contribution, the best response is not to confirm the misunderstanding. It is to explain that indeed the juror's contribution is being faithfully acted upon. Judges have the power within a statutory range to determine the punishment for the crime that the juror did find beyond a reasonable doubt, and that the judge may take into account facts about the defendant that the judge determines to be more probable than not, even though the jurors could not find those facts beyond a reasonable doubt. That difference is a cornerstone of criminal procedure, and it is the distinction that has been embedded in our common law legal tradition for hundreds of years, end quote. In other words, the judge and the jury both have a role. The judge's role is to sentence. The jury's role is to convict. Roles are not currently being contravened. They're not being confused. They're still very clearly in their proper places. Moving down to my second response to the 1AC, which you can tag as the jury still determines what legal range is used. The jury still determines what legal range is used. This is from the Vera Institute director, Ram Subramanian, wrote on July 8th, 2013, quote, Allain versus United States, Sixth Amendment requires jury-based fact-finding where facts trigger higher sentences. Defendants have Sixth Amendment rights to demand that any fact which enhances a sentence's statutory maximum be found by a jury beyond a reasonable doubt, end quote. In other words, the jury determines what legal range is used. They set the legal range, and then the judge has some discretion within that range. Therefore, once again, the jury's role is not being contravened. The jury simply sets the general range, and the judge decides time within that range. Moving down to a third point of clarification, which you can tag as acquitted conduct sentencing upheld to a constitutional level of evidence. Acquitted conduct sentencing is upheld to a constitutional level of evidence. This from Robert Elrick stated on November 3rd, 2019, quote, in United States versus Watts, the U.S. Supreme Court held that the consideration of acquitted conduct by preponderance of the evidence standard at sentencing did not violate the double jeopardy clause, end quote. In other words, acquitted conduct sentencing is held to a preponderance of the evidence standard, which was I'm so sorry, my stutter's acting up a bit, which was further agreed to in cross-examination to be a constitutional level of evidence. Therefore, ACS is currently being upheld to a constitutional level of evidence, and therefore their first harm fails, because currently the current system is not unconstitutional. ACS is being upheld to a constitutional standard of evidence. My fourth point of clarification you can tag as acquitted conduct sentencing is not mandatory. Acquitted conduct sentencing is not mandatory. Now, so far, it has been assumed that this is mandatory, right? That somehow judges must use acquitted conduct sentencing in all cases. Now, this is actually not the case, as we'll see in the piece that I am about to read. This is from Nancy Gershner for the Journal of Criminal Law and Criminology in spring of 2010, quote, there is no guideline provision explicitly requiring the consideration of acquitted conduct. It is part and parcel of real offense, end quote. In other words, they simply need to review it. They do not have to use acquitted conduct sentencing. In other words, it is merely one extra tool in the judge's toolbox, should he decide it is necessary. And furthermore, it is a tool that we have seen is constitutional, since it upholds the preponderance preponderance of a evidence standard, and due to the fact that the jury still determines what legal range is used, and therefore the judge is still limited even under acquitted conduct sentencing should he choose to use it. Therefore, I would argue that while the plan sounds good, while it sounds very polished and very elegant, however, there is some issues. It's been framed incorrectly. Therefore, I hope that my speech was able to bring some further clarification to today's round. Thank you so much, and I now stand open for cross-examination.
All right, can you confirm 3 minutes?
3 minutes, yes, ma'am.
All right, awesome. If the panel is ready. All right, let's go ahead and get started. First of all, congratulations on making it to finals. I just have a
Thank you,
few
you too.
questions
Yeah.
for you. First of all, can you agree to the innocent until proven guilty standard that our nation is founded upon?
I don't believe it was founded on innocent until proven guilty. I believe it was founded more so on the right to freedom and giving each man his due.
So is our criminal justice system founded on the principle that individuals should be considered guilty until proven innocent?
No, the justice system, that was one of the tenets which founded it, yes.
Okay, and when we're looking specifically in the U.S. justice system, how should an individual's guilt be established?
Well, it's currently being established by the jury, who then set the range, and then the judge decides what specific sentence within that range should then be applied.
Okay, so the jury should determine the guilt or innocence of an individual?
Yes, they determine guilt, but once again, there is the range left open for the judge to sentence within.
Okay, and if an individual is acquitted on all charges, should they still have time in prison?
If they're acquitted on all charges, then they should not, but your plan doesn't regard that. It's specifically regarding acquitted conduct sentencing, which means one of those charges had to have been proven guilty.
Okay, and so when an individual is acquitted on all charges, they don't serve any time for acquitted crimes, correct?
Right, absolutely, because they haven't been charged with anything. Yes, they wouldn't go to sentencing because they were acquitted.
Okay, and you would agree that it is the affirmative's contention that under the status quo, individuals are being sentenced higher for crimes for which they were acquitted, correct?
Right. So, in a preponderance of the evidence is a relatively high standard. Now, in the current system, judges can use the preponderance of the evidence to use acquitted conduct sentencing. Therefore, what we see is, in fact, that while the jury may not have had the evidence necessary to sentence somebody or to convict the person, however, we do see the judge has the necessary level of evidence to therefore extend their time in prison.
Okay, and when you brought up specifically the statutory maximum, would you agree that the range between the mandatory minimum and statutory maximum is typically very broad?
I think I could, but I'd like to see some evidence regarding that.
Okay, awesome. And you brought up the case of Watts. Your evidence specifically said that Watts addressed the double jeopardy clause, correct?
Absolutely, but I was talking about more than simply that. I was talking about how it's upheld to a preponderance of evidence standard, which you agreed was constitutional standard.
And can the Supreme Court review an amendment that is not presented to it in a case?
I'm not sure about that, honestly. It would be great to see. It would be great to see future clarification on that.
All right, awesome. Thank you so much. No further questions.
Alrighty.
The affirmative team has 5 minutes of prep time, and we'll begin that now. All right, if the panel is all ready and you can all hear me all right? Awesome. And of course, the negative team, we've got 8 minutes on the clock. Wonderful. Let's get started. There was no evidence, no DNA, conflicting witnesses' accounts, and an alibi. Yet Mr. Claiborne and Mr. Richardson were sentenced for murder. Not because a jury found them guilty of the crime, but instead because a judge disagreed with the acquittal and sentenced based on that decision. It is because we as the affirmative team in today's debate round believe that that very practice is inherently unjust, that we would advocate for reform today, where we create a system where the sentence imposed is based on the jury's finding of guilt. In this speech, I'll be responding to all the contentions brought up by the negative team in their last speech and showing you at the end of the day that an affirmative ballot is not only warranted, but completely necessary. You can tag the first response as violation of the judge's role. Again, violation of the judge's role. When we're talking about the roles of both the jury and the judge, there's a clear distinction to be made. The jury establishes guilt, and then the judge imposes a sentence based on that crime. When you have the use of acquitted conduct sentencing, it's the very opposite of that. Instead of guilt being based on that sentence, you have the judge disagree, establishing guilt themselves and sentencing based on that. According to Patricia Phipp, a federal judge in the D.C. Circuit in December of 2015, she wrote that, quote, allowing judges to materially increase the length of imprisonment based on facts that were submitted directly and rejected by the jury is too deep an incursion into the jury's constitutional role, end quote. The very use of acquitted conduct sentencing goes against the delineation and distinctions between the two separate roles in the justice system. An affirmative ballot solves that issue, which leads us to the second response. You can write down as unreasonable sentence. Again, unreasonable sentence. Now, the negative team contend that because the sentence was still inside a determined range, it was a justified sentence. But that's simply not what we see when we examine the facts of this specific case. When we're talking about federal sentencing, it's important to make a distinction here. There are two main standards that a judge must consider. First, you have the mandatory minimum and maximum, a very broad range. As the U.S. Sentencing Commission notes, for certain crimes, the range can span from 5 years in prison to life in prison. It's intentionally a broad range. And yes, acquitted conduct sentencing cannot exceed that range for the original crime. But because it's a broad range, that's not very significant. Instead, what's significant is when we turn to the guidelines, a much more tailored and specific sentence imposition. And what acquitted conduct sentencing does is it takes the guideline range from the original crime and substantially increases, as again noted by Patricia Phipp, a federal judge in the D.C. Circuit. We can also see a clear example of this injustice when we look at past instances of acquitted conduct. In one case, as Circuit Judge John O'Neill noted in March of 1993, in one example, the difference in sentence was, quote, 13 times higher than the sentence he would have received had he been sentenced under the guideline range applicable to the conduct of which he was convicted, end quote. When we talk about the use of acquitted conduct sentencing, it's a substantial and unreasonable increase in sentence. The minimum and maximum are not relevant here. Instead, we look at the guidelines and exactly what changes here. In one case, 13 times higher. That's unreasonable and a substantial difference in the sentence imposed. Which leads us to the third response. You can write down as unaddressed by the Supreme Court. Again, unaddressed by the Supreme Court. When we look at the specific precedent of Watts versus United States, we must make very clear what Watts did and did not say. As the Due Process Institute noted in August of 2019, quote, but Watts merely held that a sentencing court did not violate the Fifth Amendment's double jeopardy clause by consideration of acquitted defendants. No Sixth Amendment challenge was raised or considered in Watts, end quote. When we're talking about Supreme Court precedent, the Supreme Court has not ruled on the constitutionality of acquitted conduct as it pertains to the Sixth Amendment and the very right to a trial by a jury of your peers. Watts simply does not address the question raised by the affirmative team today, which does the Constitution allow a judge, instead of a jury, to determine the guilt of a defendant and sentence based on that determination? The answer is quite simply no, which leads us to the fourth response. You can write down as no judge discretion. Again, no judge discretion. When we're talking about the status quo, it does not allow judge discretion, and instead judges must consider acquitted conduct. As noted by Marie Murray, a law clerk in the U.S. Court of Appeals, published in the fall of 2010, she, quote, "Sentencing judges now saw themselves as obligated to admit prior acquitted conduct into sentencing hearings with only minimal consideration of the reliability of the evidence supporting that conduct," end quote. Another source from the National Association of Federal Defenders, published in September of 2019, notes that judges that categorically refuse to consider acquitted conduct risks reversal for insufficiently weighing the guideline calculations. When we're talking about the use of acquitted conduct sentencing, judges are forced to consider and apply this principle, even when they disagree, as was noted in the first affirmative constructive. Over 80% of judges disagree with this practice, yet in the status quo, they are forced to follow the guidelines. That's the very antithesis of judge discretion, which leads us to two final points of clarification and substantially proving the harm we see in the status quo. The first you can write down as pervasive practice. Again, pervasive practice. When we're talking about the use of acquitted conduct sentencing, it's not isolated incidents, it's not just one or two examples. Instead, it's widespread and pervasive in the status quo. As noted by the National Association of Federal Defenders and Families Against Mandatory Minimums in 2019, quote, "The pervasive punishment of acquitted conduct in federal courts contaminates every phase of the criminal process." Shannon O'Teal, the founder and president of the Due Process Institute, noted in 2021, quote, "Acquitted conduct sentencing remains permissible in every federal court. And based on the number of federal appeals, we know the practice is widespread," end quote. When we're talking about this practice, it's a significant issue that is not being addressed in the status quo. With an affirmative ballot, you solve that problem, which leads us to a second point of clarification. Judge discretion is preserved. Again, judge discretion is preserved. With an affirmative ballot, we're not taking away judge discretion in any way. At a sentencing hearing, they can still consider relevant conduct, like criminal history and the nature of the offense. But what they may not consider is acquitted conduct. It's the only restriction in place by the affirmative team. All other judge discretion remains, and they can now enforce the law properly by sentencing a defendant based on the crime of conviction. Thank you.
Alrighty, whenever all my judges are ready. Alrighty, I've got 3 minutes on the clock, and I'll go ahead and begin. First of all, you mentioned a lot about how ACS is mandatory. Did you ever present evidence that in fact ACS is forced?
Yes, judges are forced to consider acquitted conduct in any circumstance where it would apply.
Okay,
if they don't, they risk reversal.
Okay, fantastic. Are they forced to use it?
They are forced to use it if it meets the standard of preponderance.
Okay, interesting. Do you have any evidence regarding that?
Sure, that's exactly what the evidence said, that they are forced to consider it where it applies. If it doesn't apply, then they can't enforce it, but
Okay.
where it does apply, they must.
Fantastic. Can we actually have that piece?
Sure,
Mind
and you're
if
welcome to ask me
I
another
pass that
question.
back?
Of course not.
All right, fantastic. You mentioned preponderance of evidence, and if it were to meet the preponderance of evidence, then they have to use it. Can we agree that a preponderance of evidence upholds a constitutional standard of evidence?
It upholds a constitutional standard of evidence only as it applies to relevant conduct, as noted by Apprendi versus United States. That would apply to things like determining the number of victims at a sentencing hearing. Where it should not apply is determining a defendant's guilt. It's the lowest possible standard of evidence in a criminal trial and should not be used for determining guilt.
Okay, but it is constitutional. Thank you. All right. Next, specifically regarding y'all's plan, is Congress allowed to reverse your bill?
To reverse our bill,
To reverse your
Congress would be passing our policy under an affirmative ballot.
Okay, so they would not be allowed to reverse your bill.
They would be passing it under our policy. We don't make any distinction that Congress can no longer pass bills afterwards, if that's what you're asking.
Okay, all right, so there's no provision in place which states that Congress could reverse your bill.
No, there's no specific provision. Our policy delineates that Congress will change the sentencing guidelines, making acquitted conduct sentencing illegal.
All right, fantastic. You mentioned how ACS is commonly used. How
Yes.
often is it used, and do y'all have numbers regarding that?
Yes, we do have numbers. The unfortunate situation is because acquitted conduct sentencing is included in the guidelines, there's no exact specifics on every time it's used. That's why we have to look at the other evidence that delineates its pervasive and widespread. We do have the number of appeals if that's a number you'd like to look at, though.
Okay, so you don't have numbers as to how often ACS is actually used. You simply have the number of appeals.
We have the exact number of appeals. We don't have the exact number it's used in every criminal case because it's not directly cited. That's why we look at other evidence that shows it's widespread and pervasive.
Okay, interesting. Furthermore, are judges limited by a statutory range?
Yes, when a judge imposes a sentence, it is based on the mandatory minimum maximum and then the guideline specifically inside that range.
And the judge sets that range, correct?
The guideline range? No, it's calculated based on the nature of the
Okay, interesting. I
offense.
read a piece within my first speech. Do you have any rebuttal to that?
Which specific piece of evidence are you
Absolutely, the
referring
one that stated that the jury sets the range.
to? That the jury sets the range? Yes, that's specifically talking about the range of the minimum and maximum, which again is very broad. We have to look at the guidelines, which is what acquitted conduct sentencing changes.
Okay, and it is set by the jury. Thank you.
Are my judges ready? And the affirmative? All right. The affirmative has 3 burdens in today's round. 1, show a significant problem. 2, show they solve it. 3, prove a net advantage. I'd like to show you why none of those is true in the next 8 minutes. Begin with the arguments Trinity made in the 2AC. Her first 3 arguments was that there's currently a violation of judge role, that unreasonable sentences exist as a result of ACS, and that this issue is unaddressed by the Supreme Court. You can simply tag my response as no significant harm. Again, no significant harm. Let's talk about the harm specifically. The first harm in the 1AC is they claim that the role of the jury is undermined. This is not true, however. Whenever a jury convicts a defendant of a crime, then they're signing a check to the judge saying, yes, we approve of a sentence relating to this crime. As has been established by David and agreed in cross-examination, under no circumstances, even with acquitted conduct sentencing, can a defendant's sentence exceed the statutory maximum for the crime of which they were convicted. So if the range is 5 to 10 years, and the defendant's sentence would have been 10 years, ACS can't extend it beyond 20 years. The defendant, or rather the jury, consents to that sort of sentence being imposed on the defendant when they find them guilty. There is no violation of their role. Second, they claim the current system is unconstitutional. Now this is interesting. Both sides agree that on the Fifth Amendment issue, ACS is perfectly constitutional. However, as agreed, there has never been a Sixth Amendment charge against the practice of ACS in federal courts. It was agreed in cross-examination that the Supreme Court is the arbiter on what is and isn't constitutional. And if the Supreme Court doesn't say something isn't unconstitutional, we can assume that it is fair. For example, the Supreme Court has not explicitly ruled that Ben Brown can be on this stage at this time, this day, etc. We can, however, assume it's constitutional because nothing has been said about it. Similarly, ACS has never been found unconstitutional in relation to the Sixth Amendment. The affirmative's only argument is it's kind of bad and it kind of has something to do with the Sixth Amendment, so clearly it's unconstitutional. Well, no, the Supreme Court hasn't said that. They're the authority as agreed, thus there's no harm. Next, I want to talk about Trinity's argument about how there's no judge discretion. She had 2 arguments about that, her 4th and 6th points. I've got 2 responses. Tag the first as wording. Again, wording. Now, the affirmative evidence sounds compelling, but let's look at what it said. The first piece merely says that judges saw themselves as obliged to use ACS. That doesn't mean they actually have to. And their second piece, and this was what their stance was in cross-examination, is that judges are merely required to consider acquitted conduct sentencing, not necessarily use it. But even if they were forced to use it, you can tag my second response as discretion in the standard. Again, discretion in the standard. Here's how ACS works. If at sentencing a judge decides that the evidence shows beyond preponderance thereof that an individual did something, then they can have their sentence enhanced. The judge decides what is and isn't past that standard. They're the arbiter. To declare that the judge has no discretion is patently false. If they don't want to use ACS, they can simply decide and realize the fact that the evidence doesn't approve as such. And they are the sole arbiter in this matter, mind you, so they do have discretion, contrary to what the affirmative would have you believe. So we see there is no significant problem in the current system. ACS is not unconstitutional, it does not violate the jury's role, nor are judges forced to use it. But even if all of that was true, the affirmative plan doesn't do anything about it. I'm going to tell you about 2 reasons why the affirmative plan doesn't fix this issue. You can tag the first as impossible to enforce. Again, impossible to enforce. The affirmative plan is pretty simple at face value. Ban ACS. The question then becomes, how do you do that? The answer is you can't. As Professor Douglas A. Berman, writing for Sentencing Law and Policy in June of 2021 says, quote, no judge in any of our 94 distinct federal judicial districts is required to document when he or she relies on acquitted conduct in their sentencing decision, and there is often inadequate documentation of acquitted conduct sentencing placed on the public trial record, end quote. In other words, if a judge wants to consider acquitted conduct after the affirmative plan, they just have to keep their mouth shut about it, and the result is the exact same. And even if they do slip up, they're effectively invincible on this issue, as pointed out by attorney Chung Wong in July of 2017. He says, quote, a judge is entitled to alter his or her reasoning because the order is paramount, rather than the way in which you come to the decision, end quote. Even if a judge does on the front end say, I did this because of ACS, they can change their official decision after the fact. In short, you can't ban ACS unless you can prove that people are actually doing it. All judges have to do is start calling it something different, and they're fine. There are a variety of reasons that you can enhance someone's sentence in the current system. ACS is just one of them. As long as judges don't say acquitted conduct sentencing in their decisions, the result is the same. The affirmative does nothing to ensure justice. The second reason the affirmative does not solve the problem, you can tag as other routes create the same results. Again, other routes create the same results. I'm going to have 2 subpoints explaining this. The first of which you can write down as A, role of the prosecutor. Again, role of the prosecutor. It was agreed in the first cross-examination the role of the prosecutor is to convict the defendant. This is self-evident. It was agreed in cross-examination. There is no contest here. You can tag subpoint B, however, as uncharged conduct. Again, uncharged conduct. Michael Lowe writes for Dallas Justice on April 27, 2018, quote, the standard practice in federal court is that uncharged or even acquitted conduct can be added to a defendant's relevant conduct for the other counts for which he's convicted, as long as it can be 1, proven by a preponderance of the evidence, and 2, it is related in some way to the crime of conviction, end quote. In other words, this thing called uncharged conduct and acquitted conduct are held to the same standards. It has to be related to the crime. It has to be proved beyond preponderance of evidence. All prosecutors have to do is only charge the 1 or 2 crimes that they think an individual is most likely to be convicted of. And when they get that conviction after the affirmative plan, they are allowed to enhance the defendant's sentence by simply appealing to uncharged conduct rather than acquitted conduct. This has 2 impacts. Number 1, the affirmative plan fails to solve the problem. The outcome is the same. As long as prosecutors don't charge a specific crime, they're able to effectively get a defendant sentenced for it if they're able to convict them of a different crime. But second of all, it effectively creates backlog. If prosecutors have an incentive to charge crimes 1 by 1, since they want them to be uncharged at the time, rather than charging them all at once, you're holding more trials per defendant. That increases the federal backlog, thereby obstructing justice. But let's suppose the affirmative did solve the problem, that the last 6 minutes of argumentation are invalid. Even in that case, the affirmative creates more harm than good. And that takes us to the disadvantage, the plea bargaining trade-off. Again, the plea bargaining trade-off. I again have a few subpoints. A is plan decreases plea bargains. This is from FindLaw's team of legal writers in February 2019. Quote, a big reason for agreeing to a plea bargain is to avoid jail time, end quote. This is obvious. The reason people take plea bargains is because rather than going to trial and risking a higher sentence, they'd rather take a lower sentence and not roll the dice. At face value, the affirmative plan appears to decrease sentencing length for defendants. That's the perception. And for that reason, if people know it's less risky to go to court, they're not going to take plea bargains. That's a problem as seen in subpoint B, the first impact, increased sentence length. Again, increased sentence length. This is from Nora Eckert, Angela Roberts, and Shruti Bhatt, writing for Injustice Watch on December 21st, 2018, quote, defendants who reject plea bargains and are convicted when they choose to go to trial for many types of crimes face longer sentences than defendants who make a deal, a Capitol News Service analysis shows, end quote. In other words, the perception is that by ending acquitted conduct sentencing, people get lighter sentences. That's what incentivizes people not to take plea bargains. The reality is that that's not true. In reality, people get longer sentence lengths instead. However, it gets worse than that. Subpoint C is the second impact, backlog. Again, backlog. This is from Justia in October of 2021. They say, quote, prosecutors face overburdened schedules and limitations on their resources. Plea bargains are efficient and inexpensive, and they guarantee a favorable result instead of the uncertainty of going to trial. Many prosecutors are proud of their success rates and are evaluated on this basis, end quote. Later in the article, it says, quote, the criminal justice system is greatly overburdened. Judges have full calendars and may be concerned they can't effectively try every case, end quote. In other words, by disincentivizing plea bargains, the affirmative sends more people to court, which in turn exacerbates the already terrible federal backlog that existed before COVID. It was made even worse by it. Thus, because the affirmative fails all three of its burdens, I ask for your ballot. Thank you.
All right, if the panel is ready to proceed, and of course a negative speaker.
Yes.
Wonderful, we got 3 minutes.
Uh-huh.
Awesome, let's get started. First off, congratulations on making it to finals. I've just got a few quick questions for you. First off, would you agree that a jury should determine the guilt of a defendant?
Yes.
All right, perfect. And if you were brought before a criminal court and you were acquitted on all charges, should you receive any prison time?
No, if you commit a crime, you should be punished.
Okay, but if you were acquitted on all charges, you should not receive any prison time.
Correct.
Awesome. All right, and a sentence should be based on the crime of conviction, correct?
Yes, and that's why under no circumstances, even when ACS is used, are judges allowed to impose sentences greater than the statutory maximum.
Okay, you would agree acquitted conduct sentencing includes the calculations of that acquitted conduct?
Can you clarify what you mean? That's a bit circular.
Sure. When we apply the use of acquitted conduct sentencing, the calculation includes that conduct, even if it's within the charges of a separate crime.
If you're asking when we apply acquitted conduct, do we factor in their original sentence, quote unquote, plus the enhancements, then yes.
All right, perfect. All right, and you talked about the Supreme Court and how it has not ruled that acquitted conduct sentencing is unconstitutional. You would agree if that was the case, then it would be illegal in the status quo?
Yes, and the fact that ACS exists is a testament to the fact that, by the laws of the land, it is constitutional.
Okay. Did you bring up a specific circumstance where the Supreme Court ruled it was constitutional, or is your argument here that because they have not heard the case, it's constitutional?
As I explicitly clarified, nobody has ever accused ACS of being unconstitutional via the Sixth Amendment. One, there's probably a reason no one's ever made that allegation, and two, the fact nobody has made that allegation means it is a legal and thus constitutional practice.
Okay, interesting. All right, and you would agree when we apply the use of acquitted conduct sentencing, it changes the guideline calculation, it increases it?
It increases what a person's sentence otherwise would be, but it doesn't exceed the statutory maximum, no.
Okay, perfect. And you would also agree that when a judge varies from the guideline calculation, they have to cite a reason for that variance?
One, we haven't seen evidence on that.
Okay.
Two, even if that was the case, as the evidence I read demonstrates, they don't have to say ACS is the reason. Again, there are a variety of reasons for which an individual, or a judge rather, could enhance a sentence.
All right. And when we're talking about uncharged conduct, that was not presented or ruled upon by a jury, correct?
Yes.
Okay.
Crime of
And
which-
you would also agree uncharged conduct is not required to be considered at a sentencing hearing?
No, it's held to the same standards as ACS.
Okay, interesting. All right, and you would also agree that defendants have a right to a trial by jury, correct?
Sure, that's guaranteed by the Sixth Amendment of the United States Constitution.
Awesome. And then my final question, you mentioned the idea of a backlog in the courts. When was a specific date on that evidence?
I argued about backlog twice in the speech. Which argument are you referring to?
Either piece of evidence.
Okay, sure. The first argument was a logical conclusion of the impossibility argument.
The dates on the evidence.
The
sorry,
dates on the
clarify.
evidence. Let me pull that up real quick. That evidence was from October of 2021.
Perfect. And would you mind if we have a copy of that evidence?
Yes, it starts on this page and goes on to the next.
Perfect. And if we could also have the evidence regarding plea deals increasing?
That's on the same page.
Okay, perfect. Thank you so much.
Alrighty, I've got 5 minutes on the clock, and if all my judges are ready. Alrighty, then we'll go ahead and begin. Quote, when a layperson expresses frustration that the court system does not seem to respect the juror's contribution, the best response is not to confirm the misunderstanding. It is to explain that indeed the juror's contribution is being faithfully acted upon. Judges have the power within a statutory range to determine the punishment for the crime that the juror did find beyond a reasonable doubt, and that the judge may take into account facts about the defendant that the judge determines to be more probable than not, end quote. In other words, the judge's role, as defined by the Sixth Circuit Court, is that it has the power to use acquitted conduct sentencing. Moving down into some responses to the second affirmative speech, their first point was that regarding how essentially it was a violation of the judge's role. They actually had three very similar points. Their other points was asking whether the U.S. Constitution allows a judge to sentence. And their third point was that about judge discretion. I'd like you to group all those together, and you can tag my response as the Sixth Circuit says it does. The Sixth Circuit says it does. Says it does what? Well, it says it has the ability to use ACS. In other words, the Sixth Circuit grants judges the ability to use acquitted conduct sentencing in cases. Therefore, once again, we've seen that, in fact, it is not the violation of the judge's rule, but in fact, courts have ruled that it is part of their role. Moving down to some other responses to the 2AC, they talked about how it's an unreasonable sentence, and they also talked about how there's a 13-time difference from what the gentleman would have been sentenced for if he had been convicted of only one thing, and they have not used acquitted conduct sentencing. Essentially, the 13-to-1 disparity. You can tag. I've got a few responses to this. The first of which you can tag is high standard of evidence. High standard of evidence. Once again, ACS requires the preponderance of the evidence. Well, what does that mean? Well, it means it is a very high standard to be able to use acquitted conduct sentencing. In other words, it cannot be used if there's not much evidence regarding it. Therefore, judges in these scenarios have a high standard of evidence to be able to support their points and to be able to back up their acquitted conduct sentencing. Moving into my second response, you can tag it as already convicted of a crime. Already convicted of a crime. These people are not innocent. They have been convicted of a crime, and therefore, what's simply occurring is that they're being that they're being sentenced for a longer amount of time. It's not as if these people have gone off scot-free, or that they are innocent individuals. Moving down to responses to the 2AC's later points, they mentioned in the first clarification essentially that of how using acquitted conduct sentencing was a pervasive practice. You can tag my response as no evidentiary proof. No evidentiary proof. So we heard that it was supposed to be pervasive. We heard this general piece stating it, but we don't know how many. Is it one? Is it two? Maybe three people sentenced using ACS? We don't know. There's no numbers, and therefore there's no proof to uphold this point. Their final point was their second clarification, and it was talking specifically about how under their plan, a judge's discretion is still preserved. Here's two reasons why in fact their plan limits judge discretion. The first, you can tag as depriving judges of a tool. Depriving judges of a tool. Judges have tools by which to sentence prisoners, right? ACS is one such tool, which can be used to grant prisoners more time in prison based off of a preponderance of the evidence. My second point you can tag as the tool is limited in power. The tool is limited in power. This is not an unlimited power tool. Once again, from the Vera Institute director, Ram Asubramanian, wrote on July 8, 2013, quote, "Alain versus United States Sixth Amendment requires jury-based fact-finding where facts trigger higher sentences. Defendants have Sixth Amendment rights to demand that any fact which enhances a sentence's statutory maximum be found by a jury beyond a reasonable doubt," end quote. Essentially, the Supreme Court ruled in Alain that judges must give sentences within the legal range for the crime that the jury convicted the defendant of. Thus, judges cannot increase sentences beyond the legal range because of acquitted conduct sentencing, because acquitted conduct was not proven by a jury, end quote. That was not part of the quote. In other words, the crime that the jury was convicted of can be enlarged upon by the judge. Thank you so much, and it has been a pleasure trying to speak for you today.
The affirmative team has 3 minutes and 51 seconds of prep time remaining. We'll begin now.
You're ready? Awesome. And if the panel is ready? All right, let's go ahead and get started. The U.S. criminal justice system was founded on the principle that an individual is innocent until proven guilty, that it's better that 10 guilty people go free than that one innocent person is wrongfully punished. And it's because acquitted conduct sentencing undermines this very principle that we believe at the end of the day our plan is warranted. And in this speech, I'll be responding to the points of the negative over the last two speeches. My first response you can write down as significant problem. Significant problem. When we're looking at these changes in an individual sentence, it is a drastic change. In fact, according to Professor Yang Allen Gov, published in 2009, quote, because of the dramatic impact that consideration of acquitted conduct can have on a defendant's liberty, it is by no means a trivial matter, end quote. When we're looking at this, we're looking at drastic 3, 4, or 13 times increases in a defendant's sentence based specifically on conduct for which an individual was acquitted. The negative also asks for numbers. We see that this has been appealed hundreds of times, and we can provide that specific piece of evidence to the negative if they would like to see it, but based on simply the number of appeals alone, we can see that this is a widespread and pervasive issue. And you can tag my next response as risk reversal. Risk reversal. Now, the negative contended that, well, judges don't actually have to use acquitted conduct sentencing. However, what the evidence my partner read specifically said is that if judges do not consider or fail to consider where acquitted conduct sentencing can be used, they risk the reversal of their decisions. You can write my next response down as written reason. Written reason. Now, the negative contended that our plan is impossible to implement because, well, judges don't have to track when they use acquitted conduct sentencing, so we aren't changing anything. However, according to the Office of General Counsel and U.S. Sentencing Commission, published May 2014, quote, if the court departs from the otherwise applicable criminal history category, it is required to specify in writing the reasons. Remand is appropriate when the district court fails to adequately explain the basis for its departure, end quote. So currently acquitted conduct sentencing is in the guidelines. Our plan changes U.S. code and removes it from the guidelines. If a judge then uses acquitted conduct sentencing, they have to give the written reason for why they're departing from the guidelines, and ultimately they will not be able to do that. This does change the current system, and it will be a solvent plan. You can write down my next response as 80% want removed. 80% want removed. Now, the negative contended that, well, judges may still use uncharged conduct to increase an individual sentence. However, I read evidence in the first speech regarding how 80% of judges want acquitted conduct sentencing to be removed. It's not like they're going to be trying to work around. Additionally, uncharged conduct is different from an acquittal. It's not something that a jury has ruled an individual not guilty of. And finally, there is no obligation to consider uncharged conduct, while there is an obligation to consider acquitted conduct sentencing within the status quo. This argument simply doesn't apply. Now, looking specifically at the negative argument regarding plea bargains, you can tag my response as unsubstantiated claim. Unsubstantiated claim. You see, the negative's claim was simply that people are not going to take as many plea bargains with the affirmative's plan. But they didn't provide any evidence saying that. They just provided evidence regarding how plea bargains are a good thing. This claim was unsubstantiated. And additionally, you can tag my second response to that point as constitutional right to a jury trial. Constitutional right to a jury trial. If more individuals take a jury trial, that's not necessarily a problem within the status quo. Individuals have a constitutional right to a trial by jury. Now, this brings me to my next response, which you can write down as lower courts are bound. Lower courts are bound. Now, the negative presented evidence that, well, the Sixth Circuit Court says acquitted conduct sentencing is constitutional. Therefore, it is constitutional. However, when we look at specific evidence from, again, Professor Yang Allen Gov, she writes about how district courts and judges in the circuit courts have questioned the viability of Watts, but because of the ruling in Watts, they feel that they are bound by that decision. Even though it only addressed the Fifth Amendment, because it's the only ruling, they feel bound by that. We can't look specifically at those rulings within today's debate round. Which brings me to my final response, which you can write down as lowest standard of proof. Lowest standard of proof. And the negative contended, well, there's still a standard of proof when using acquitted conduct sentencing. However, it's the preponderance of evidence standard. It is the lowest standard of proof. It should only be used to determine the circumstances of the convicted crime and not used to look at conduct for which a jury ruled that an individual cannot be proved guilty beyond a reasonable doubt. This would undermine the criminal justice system and is, at the end of the day, a massive problem that the Affirmative's plan solves. Thank you so much, and it's been a pleasure speaking for you.
Judges ready? Y'all confirm this is 5? All right, let's start. In this last negative speech, I want to do 2 things. First, I want to directly respond to a few of the arguments you just heard, and second, I'd like to collectively respond to the affirmative philosophy with 3 voting issues, summarizing the negative stance in this round. Starting with direct responses, I want to address their arguments about 80% of judges wanting acquitted conduct sentencing removed. I'd like to observe that those judges aren't going to impose acquitted conduct or uncharged conduct in either world. Acquitted conduct is not something judges are forced to use. They're forced to consider it, as the affirmative evidence says, and they have reiterated, but they are not forced to use ACS. The 80% of judges that want ACS removed presumably don't like it and don't use it. They're forced to consider it, but after consideration, they routinely reject it. What those individuals do is not influenced by the affirmative plan, thus there is no solvency. Next, they talk about the lower courts issue. I just wanted to clarify here, I don't think there's any offensive arguments. Their evidence merely says that lower courts are bound by the Watts decision, which is true. Now, having responded to those arguments, let's talk about the voting issues. Let's come back to those 3 burdens I talked about at the beginning of my last speech. Voting issue 1 is no harm. Again, no harm. I made this assertion in my first speech. The affirmative's counter-assertion was that there's a significant problem. They read a piece of evidence talking about how ACS impacts freedom. Well, of course, you're going to jail longer, perhaps, so it does impact your freedom. But whether there's a significant problem in that impact of freedom is something that has yet to be determined. First of all, the affirmative ignored the analysis under that argument about how ACS has not been ruled to be unconstitutional. It's legal under the 5th Amendment. Nobody has ever charged it with being illegal under the 6th Amendment. If something hasn't been ruled unconstitutional, then it presumably is otherwise. Again, the Supreme Court hasn't said it's constitutional for me to be here today specifically, but they haven't ruled otherwise. I thus presume I can be here. The same logic applies. ACS has not been ruled unconstitutional. The affirmative just says it's bad, which it isn't, but even if it was, bad does not equal unconstitutional. And second of all, it does not undermine the role of the jury. Again, when a jury convicts a defendant, they are approving a sentence for that crime. And what that sentence can be is determined by the mandatory minimum and statutory maximum. Under no circumstances, even with ACS, can a judge enhance a defendant's sentence to exceed the statutory maximum of the crime they were convicted of. And third, again, there is no evidence acquitted conduct sentencing is forced. They are forced to consider it, but not to use it. That point alone warrants a negative ballot. I want you to circle those two harms that the affirmative presented in their first speech, undermining the jury and jeopardizing the Constitution. If affirmative can prove to you that at least one of those is a significant problem, then consider the other burdens. But if I've shown you that neither of those is true, then I ask you to vote negative. Supposing you believe at least one of those is significant, however, let's talk about the second voting issue, no solvency. Again, no solvency. I'm going to have two subpoints here. Subpoint A is no way to track. Again, no way to track. I brought up this argument in my last speech. Judges are not required to specify in writing when they use ACS. Affirmative's response was that they're required to give a written reason, and that's true. But again, as specified, there are many, many ways that a judge can justify an upward departure from what they otherwise would have imposed as a sentence on the defendants. They don't have to specify ACS, they can use another reason for doing so. And even if that wasn't true, I'll point you back to the evidence I read in my last speech proving that if a judge doesn't like what their original justification for increasing the sentence was, they can always change what their decision is. They can always change their justification for departing. The affirmative response does not deal with the heart of the argument I presented. As long as judges are not forced to document when they use acquitted conduct sentencing, it is impossible to outlaw it. Subpoint B is consider versus use. Again, consider versus use. I talked about the issue of uncharged conduct in my last speech and how that would effectively replace acquitted conduct. Affirmative's response is that people are not, or judges are not required to consider UCS, uncharged conduct sentencing, in the same way they're required to do so with ACS. That may be true, but the judges who currently use acquitted conduct sentencing do so because they want to. They are forced to consider it, but they choose to use it of their own free choice. They want to enhance the defendant's sentence. That holds true after the affirmative plan. Even if those judges aren't forced to consider UCS, the status quo proves that they want to use it and will do so without being forced to consider it. There is no solvency. Uncharged conduct replaces acquitted conduct. If you pass the affirmative plan, it's held to the same standards. And additionally, that creates the backlog issue I talked about in my last speech. But let's now talk about the third voting issue, net harm. Again, net harm. Even if the last 4 minutes of argumentation are invalid, the affirmative creates more harm than good. Their response to my disadvantage about plea bargains was that it was an unsubstantiated claim. They ignored my analysis here. Under the affirmative plan, the sentence an individual would receive in court is perceived to be less by defendants. Thinking that they can get a lighter sentence, they choose to go to trial more often. But in reality, as the evidence I read proves, when defendants reject plea bargains, they consistently get higher sentences than they would have if they accepted the deal. That, again, increases sentence length and increases backlog. Thus, because the affirmative plan, 1, presents no significant issue, 2, fails to solve it if it was there, and 3, creates more harm than good in the process, I ask for your ballot. Thank you. It's been a pleasure speaking for you.
The affirmative team has 2 minutes and 16 seconds of prep time remaining. We'll begin that now. If the panel is ready? Awesome. And of course, the negative team, we've got 5 minutes on this. Legal expert Jay Stewart said that, quote, the unconstitutional scourge of acquitted conduct sentencing must be abolished, end quote. This was all the way back from the first affirmative constructive. And it's because we as the affirmative team agree with this expert that the unconstitutional scourge of this practice must be abolished. They would ask for an affirmative ballot today. In this speech, I'll be going over 3 main voting issues in response to the negative team's contentions and proving the value and necessity of an affirmative change. Which leads us to the first voting issue. You can write down as pervasive injustice. Again, pervasive injustice. When we're talking about the use of acquitted conduct sentencing, it's widespread, it's pervasive, and it's unjust. We see a significant problem, not only in the numbers, but also the quality of the issue. As my partner noted, it's been directly appealed in hundreds of cases. We provided this to the negative team. We can also see that other experts show it's pervasive and widespread in the system. It's significant in terms of quantifiability, but it's also significant in terms of exactly what it does. When we look at the use of acquitted conduct sentencing, as the evidence my partner read noted, it is by no means a trivial matter. In certain cases, increases sentencing 13 times higher. This is a significant problem that goes unaddressed by the status quo. We also see that it ignores the jury's role. When we're looking at the use of acquitted conduct sentencing, as noted in the first affirmative constructive, the judge essentially disagrees with the jury and sentences based on their own determination, in direct violation of the jury's acquittal. That's a significant problem that violates the very nature of our protections as U.S. citizens under the Constitution. And then we also turn to that idea of Supreme Court precedent. And again, we'd like to make some clarifications here. Watts never addressed the Sixth Amendment. Therefore, there has been no Supreme Court precedent on this issue. And the lack of a precedent does not mean it's constitutional. The Supreme Court doesn't rule on every single issue. That claim by the negative team was simply unsupported by evidence in today's debate round. Instead, what we do see is that experts, Supreme Court justices, have all agreed that this is unjust, as was noted in the first affirmative constructive. This is unconstitutional and unjust, which leads us to the second voting issue. You can write down as solvent reform. Again, solvent reform. In the status quo, judges must consider acquitted conduct sentencing. I point you back to the evidence I read in my speech, according to the National Association of Federal Defenders and Families Against Mandatory Minimums in 2019, where they noted that judges that refuse to consider acquitted conduct sentencing risk reversal. They must consider it in every case where it applies, which is exactly why we see the issue today. 80% of judges do not want to use it, but we see that they do use it. It's because they are forced to under the guidelines. And an affirmative ballot solves that issue. We make it illegal to consider acquitted conduct sentencing by changing the very code that dictates what sentence may be opposed. Any variance would be noted in writing and reviewed by an appeals court, as my partner mentioned. So any variation from the guidelines of the crime, an application of acquitted conduct sentencing, would not be permitted. We can also see that acquittals are protected. They contended the use of uncharged conduct, but dropped my partner's response talking about the difference between uncharged conduct and an acquittal. We're talking about 2 very different ideas here. One is something that was never considered by a jury and is not required, and then one is a determination by the jury of the innocence of a defendant that a judge must consider. We solve for that issue. We also see that judges would enforce this as they believe the policy of acquitted conduct sentencing is unjust, which leads us to the third voting issue. You can write down as justice preserved. Again, justice preserved. With an affirmative ballot, you see the advantages that were laid out in the first affirmative constructive, that we preserve the role of the jury, that their determination of innocence stands and is not overruled by the will of one judge. We also preserve the Constitution, that a sentence is based on the crime of conviction and the applicable guideline range, not the determination of a judge using acquitted conduct sentencing. And then finally, we see that those unjust standards are not applied. The protections offered in a jury trial are what stands. At the end of the day, we see a need for reform. Thank you, and it's a pleasure speaking for all of you today.
Great round, guys, and thank you so much to you seven for judging. We appreciate your time.
Thank you all for judging, and fantastic round, y'all.
Thank you all so much for judging. We really do appreciate it. A great round. Yes, congratulations to the negative team. And again, we really do appreciate you taking the time to judge.